Okay, well, good morning, everyone. It's 10 o'clock. We'll just make a slow start because I can see a few attendees trickling in. If you've got any questions through the session, you're very welcome to put them on the Q&A function. I'll keep an eye on that as we go through. I'm happy to answer questions live, and also there'll be time for questions at the end as well. So as it says on the screen, we will make available a recording and the slides of this session on the website afterwards. So you're welcome to come back or to share that with colleagues. As the title on the slide suggests, the purpose of today's hearing is to look at remote licensing hearings and reflect on the recent judgment that came out just over a week ago, almost 2 weeks ago, from the High Court, the WalkSafe judgment, which confirmed that remote hearings are lawful. And we'll also look at some best practice tips if you are an authority that already conducts remote hearings, or if you're now, in the light of this judgment, thinking of going back to using some form of remote hearings procedure. So I will just wait one more minute, I think, as I can still see some numbers ticking up slowly. We've got plenty of time. We should be finished well before 11 o'clock. All right, well, let's make a start. So thank you again for joining me on this webinar, where we'll be looking at remote licensing hearings, essentials and best practice. For those of you who are just joining us now, the recording of the session and these materials will be available on the event section of the Cornerstone website. And we've had a lot of interest in the session, which is fantastic. And it's evident that even 4 years after remote hearings became a feature of our working lives as licensing practitioners, still generates a lot of interest even now. And I know opinion has differed over the years about whether remote hearings were allowed under the relevant legislation. Well, now at last we have the final decision from the High Court, which is that remote hearings are lawful. So as you can see, I've got the overview of today's session on the slide. Firstly, we'll look at the judgment itself and explain to you why the court reached the conclusion it did, that remote hearings are permissible. And then, as I said a moment ago, we'll look at some practical implications, and in particular, the requirement to adopt a remote hearings protocol of some form. So let's look at this case then. It's Safe Security Ltd versus the London Borough of Lewisham. And I represented the London Borough of Lewisham in the High Court appeal. And in fact, I'd advised the committee that made the decision under challenge. I also represented the authority in the appeal to the magistrates courts last spring. So the factual background to the case in a nutshell was this. The premises in question is a nightclub called Silks. It had a late night license, and it operates in Catford in South London. And as you can see from this, there we go, this news report, it encountered a few management difficulties, which resulted in a series of hearings taking place before the London Borough of Lewisham's licensing committee towards the end of 2022, all of which were held remotely using Microsoft Teams. And that had been the council's practice since the pandemic. They had not reverted to in-person hearings. And among the decisions made at those hearings was a decision to revoke Silk's premises license. So the premises license holder appealed, and as well as seeking to challenge the council's decision on its merits, the Silks raised a pure point of law, which was that the decisions were invalid because they had been made following remote hearings. And remote hearings, they said, were not permitted under either the Licensing Act 2003 or the Licensing Act Hearings Regulations 2005. Now, this point was dealt with as a preliminary issue in the appeal. It was heard by District Judge Abdul Sayed in the Bromley Magistrates Court in April 2023, and she gave her judgment shortly after the hearing and said, well, in my view, remote hearings are lawful. And many of you, I'm sure, I can recognize many of the names, join me for the first version of this seminar in the wake of the magistrates court decision. So that's the factual background to the case. What about the legal background? Well, a lot of this will be familiar to you. So up until March 2020, few, if any, certainly not in my experience, licensing hearings had been held anywhere other than in the council chamber or a committee meeting room somewhere in the council building. In other words, they'd always been held in person. That became an impossibility as of March 2020 because of the need for social distancing. And in response, Parliament passed the slightly cumbersomely named Local Authorities and Police and Crime Panels Coronavirus Flexibility of Local Authority and Police and Crime Panel Meetings, England and Wales Regulations 2020. We, at the time at least, referred to those as the flexibility regulations. And you will remember that that was the legislation that enabled all local authority meetings, and I emphasize the word meetings for reasons that will become obvious in a moment, to take place remotely. And local authorities, as did almost everyone who spends a lot of time in front of a computer for their job, adapted very quickly. And a little over a year later, we have Jackie Weaver starring at the Brit Awards. Now, of course, by the time Jackie made her appearance, remote meetings for local authorities were a thing of the past, because the High Court, in the case of Hertfordshire County Council versus Secretary of State for Housing, Communities and Local Government in 2021, ruled that when the flexibility regulations expired, and they were enacted so as to automatically expire in May 2021. Once those regulations expired, the High Court held while there was no legislation that permitted local authority meetings to be held online, and therefore they all had to revert to in-person meetings. And I'm sure many of you will remember the scramble to suddenly organise in-person socially distanced meetings, and that was quite a logistical undertaking. Now, central to the court's decision in Hertfordshire was the concern that the Local Government Act 1972 did not say anything about important procedural questions governing remote meeting procedure, such as which meetings should take place remotely, who decides whether they take place remotely or in person, what criteria inform that decision, importantly, what constitutes valid attendance by members of the committee, members of the public. And all of those procedural decisions were important because they ensured that decisions made by democratically elected local authorities at public meetings were A, valid, and B, taken in a democratic way. Now, the Hertfordshire case, as I say, is concerned with the position for meetings under the Local Government Act 1972, but it doesn't say anything directly, or it didn't say anything directly, about licensing hearings taking place before the licensing committee. Now, the crucial distinction to be aware of is that an ordinary meeting of a local authority, or either full council or a committee or a subcommittee, is not the same as a hearing before that local authority's licensing committee. A licensing committee is constituted under Section 6 of the Licensing Act 2003, and it has specific statutory functions that it exercises on behalf of the council as licensing authority. And it's taken out of the ordinary scheme of delegation under the 1972 Act, which otherwise allows an authority to constitute committees and subcommittees to discharge its regular business. So what that means is that the Hertfordshire decision did not apply to licensing hearings, and therefore it was an open question whether the 2003 Act and the hearings regulations permitted remote hearings. And as I say, views differed as to whether remote hearings were lawful. Many authorities simply assumed that Hertfordshire was the be-all and end-all, and therefore they had to revert to in-person hearings, but others continued to hold hearings either remotely or partly remotely, partly in person, what we call a hybrid procedure. And in the absence of a test case, it remained unclear as to what licensing authorities were allowed and were not allowed to do. So that brings us to the case of WalkSafe, which was the first case in which the court was asked, the High Court in this case was asked to formally provide an answer to this unresolved question. Now, key to the appellant's case was that the hearings regulations require a hearing to be held on a particular date and at a particular time, and crucially at a particular place. Place, they argued, self-evidently referred to a physical location, and that it followed that the right of the parties under the hearings regulations to attend the hearing and for members of the public to be able to attend the hearing. All of those were indications, they said, that physical attendance or physical presence at a specific physical location was required. They also pointed to amendments made to the hearings regulations, which applied only in Wales and made express reference to remote hearings and set out some procedure that had to be followed for remote hearings in Wales. They said, well, it wouldn't have been necessary for the Welsh legislation to allow for remote hearings if the hearings regulations, as originally enacted, already permitted remote hearings. And they also made an argument that remote hearings had significant implications for the business involved, whose license or authorization is at stake, and had wider implications for local residents and other people in the vicinity of the licensed operation. And they said in-person meetings promoted greater certainty and fairness. Now, in response, the case that I made on behalf of Lewisham was that remote hearings were lawful. And what we said was that, well, there's no definition of a hearing in either the 2003 Act or in the hearings regulations. All that's required is some kind of process which enables the licensing committee or a subcommittee to hear evidence and hear submissions from the parties before they make a decision. There's no reason in principle why that has to be done in person. And we know very well that courts regularly do that without any great difficulty online all the time. All that the hearings regulations, the second point we made, all that the hearings regulations required was that the hearing be held at a place, but no further definition or qualification of that word appears in the hearings regulations. And therefore, in principle, a place could be a place online. And certainly post-pandemic, there's no practical difficulty really now in arranging for a hearing to take place and giving notice of a hearing to take place online. The 1972 Act says something different. It said that a local authority meeting needs to be held at a place either within or without the authority's area. And in the Hertfordshire case, the court said, well, that's particularly significant because that implies that a hearing needs to take place in a single physical location. The next point we made for Lewisham was that Section 9(3) of the 2003 Act, and there's equivalent provision in the regulations, allow a licensing committee to regulate its own procedure. And therefore, unless there's contrary provision either in the Act or in the hearings regulations, it follows that the licensing committee has the freedom to decide how it proceeds to determine cases at a hearing. So, for instance, that would include the procedural choice of whether to hold a remote hearing. The final point in response to the amendments made in Wales was that self-evidently the law applying in Wales does not apply in England. That didn't change the position that the regulations as they apply in England did not expressly prohibit or preclude the use of a remote hearings procedure, and therefore it should be up to licensing authorities to decide. And the point we made about the Welsh legislation was that was simply an illustration of how you might go about centralizing the rules for holding remote hearings. But fundamentally, licensing is a local process, and there is great procedural variation between different licensing authorities in terms of how they go about conducting their hearings. And it follows that the choice of whether to hold remote hearings should also be a local decision based on the demographic of the area, the kind that it's experienced generally with licensing hearings, the convenience to members of the public and parties attending the hearing. All of those are factors that different licensing authorities may take a different view on, and they should be allowed, or certainly we argue they have the discretion to take those factors into account and decide whether or not to go remote, in person, or hybrid. Now, essentially, the district judge last spring agreed with Lewisham's case and ruled that remote hearings were lawful. The appellant appealed by case stated to the High Court against that decision. The appeal was heard in May 2024 by Mr. Justice Chamberlain, and he handed down judgment a little under 2 weeks ago, 11th of July 2024. He dismissed the appeal. He agreed with the council and with the district judge that remote hearings were lawful. Now, let's take a few points from the judgment. So firstly, he held that a hearing can be a remote hearing. So the judge said that in the absence of an express statutory definition of what a hearing is in either the Act or in the regulations, in principle, the term hearing could be applied to an in-person hearing or to a remote hearing using video conferencing technology. There was no obvious indication in the regulations that a hearing excluded a remote hearing. Second key point was that although the regulations do require a hearing to be held in a place, because that word place is not defined and it's not qualified in a way that suggests a single geographical location, an online platform can properly be described as a place for these purposes. The next point was that licensing hearings are not meetings of local authorities, and therefore the decision in Hertfordshire, the rules in the 1972 Act which prevent a remote meeting of a local authority do not apply. There was an important constitutional difference between the two. The judge said that you can't, contrary to the appellant's case, you can't describe licensing hearings as forming part of the government of this country. That had been a crucial factor that had pointed the court in Hertfordshire against the use of remote meetings. The next point, and this is an important point which we'll come back to in the second part of this session, was that Section 9.3 of the 2003 Act and Regulation 21 of the Hearings Regulations indicated an intention to confer what the judge described as maximum procedural flexibility on the licensing committee. Now, what that meant was that the licensing committee can essentially do whatever it likes in terms of determining the procedure to be followed at a hearing, unless contrary provision is made for in the regulations. So the regulations you'll see in the judgment set out a basic procedural framework. It says things about giving notice of the hearing, where it's going to take place, when it's going to take place, allowing public access, various rules that we're all familiar with from hearings generally. All of those things can be achieved through a remote hearings procedure, and it's up to the committee to determine exactly how that will shake out. Next point was that a licensing hearing, evidently, whether it's in person or remotely, has to be fair. And because a licensing authority is a public authority, is under an obligation to act fairly. Now this requires, and again, this is a point we'll come back to in the next part of the session, this requires a licensing authority to consider whether a remote hearing can be held in a way which is fair to all parties, and crucially where it would not be, perhaps because a party either doesn't have the skills to access a remote hearing, they don't have available technology, or perhaps they don't have adequate internet connection to properly participate in a remote hearing. Some kind of alternative procedure is needed. Now, in Lewisham's case, they had conducted all of their hearings remotely, but in one case that I'd advised, and I think this was the only case prior to this hearing, they'd had an objection to a 10, and the person who'd given the 10 said, well, I don't know how to use the internet. So they were invited into the council chamber and sat next to the committee clerk, who set everything up on the internet. All of the members and everybody else in the hearing participated remotely except the person who'd given the 10. This is a classic example of where flexibility, taking a common sense approach and making sure that everybody has a fair opportunity to participate, was able to sit very comfortably with the use of a remote hearings procedure. And the final point that the judge made was that the provision in Wales simply wasn't relevant, or at least it wasn't directly relevant to the position in England. So what the judge said was that Welsh provisions simply show how one could draft a provision if the intention of the legislation was to put beyond doubt the question whether hearing includes a remote hearing. And what the judge said was, well, the hearings regulations as they apply in England were not clear one way or another, and therefore it was a question of interpretation. And because of the maximum procedural flexibility conferred by the regulations and the Act, the judge held that there was nothing to prevent a licensing authority, if it chose, and if it was fair to do so, from using a remote hearings procedure. So that's a whistle-stop tour through the judgment and why the judge reached the conclusion that licensing hearings can take place remotely. I can tell you that this is, or at least it should be, the final word on this question. There is no right of appeal against the judge's decision, because appeals by case stated end once the High Court has made a ruling on the case stated, unless you're in a criminal case. Well, this is not a criminal case, in which case there's no right of appeal against the judge's decision. Now, what this means is that all licensing authorities in England are now able to hold hearings, or it's been confirmed that they're able to hold hearings using some form of remote procedure. Now, for many, such as Lewisham, that will simply be business as usual. But for others, particularly those who took the view that licensing hearings had to take place in person, that means it might be time to dust off your old pandemic era remote hearings protocols if you're thinking about going back in some form to the use of remote hearings. And it's to that topic that we're now going to turn briefly. Now, given the maximum procedural flexibility that the judge tells us is allowed to licensing committees to regulate their own procedure, it follows from that that there is no single means by which a committee may determine the procedure that is to be followed at a remote hearing. The judge doesn't have a great deal to say on the practicalities of holding remote hearings, because he wasn't asked to consider them. His judgment, as he makes clear, was concerned purely with the question of law, whether or not the legislation allowed for remote hearings. But it's implied, I think, from the High Court's judgment that some form of protocol, something in writing, is necessary to ensure that not only is the procedure at the remote hearing fair, but just as importantly, it's seen by all parties to be fair, including by members of the public. Now, at the very formal end of the spectrum, a protocol for remote hearings before the licensing committee could be adopted and incorporated into the council's constitution. At the less formal end of the spectrum, and this, I think, this was the advice I gave to Lewisham in its case, a very simple, perhaps even one-page document setting out a kind of a skeleton set of rules for a remote hearing could simply be adopted by the licensing committee and included in the agenda and reports pack. I don't think any great deal of formality is needed, provided there's something in writing telling everybody who's going to participate in the hearing, from members of the committee to members of the public and everyone in between, how they stand and what order and what rights people have to participate in the hearing. As for what areas the protocol should cover, in my view, there are six areas, six crucial issues that it should cover. The first one is a threshold question, which is whether or not the hearing should take place remotely, in person, or using a hybrid of the two. Now, it may be, as was the case at Lewisham, that the authority has a default rule that all hearings will take place remotely. Alternatively, it may be that the default is that all hearings take place in person. I think a default rule or a presumption is probably administratively more efficient, but it's certainly open to authorities to decide each case on a case-by-case basis. And even where there's a presumption or a default in terms of the mode of hearing, it's essential that the licensing authority is always open to considering a request from a party to do something different. And ideally, the protocol should set out what criteria the committee might take into account when deciding either to go with a fully remote or hybrid on the one hand, or a fully in-person hearing on the other. So things like, so that a party who wants the authority to go down another route knows how to frame that request. So it might be that someone has mobility difficulties, which makes it difficult for them to get to the council chamber. Alternatively, they may have difficulties in accessing a hearing online, something like that. In my view, it would be lawful for the authority to say, well, the default is that all hearings will take place remotely, save for exceptional circumstances, and where it would be unfair to proceed entirely remotely. That might be enough. That probably would be enough in my view, in terms of criteria, but it's certainly open to the authority to be more specific. Now, the second issue that I think needs to be addressed by a protocol is what constitutes valid attendance by members of the committee or the subcommittee. At the absolute minimum, all members need to be able to hear the proceedings and ideally to see the parties as well, but certainly to hear what's being said. They should be capable of being heard when they have a need to speak. And I think in the interest of transparency, also to be seen as well. That doesn't necessarily mean that they need to keep their videos on all the time, but I actually think it helps if they do, because then that more closely replicates the experience of being an in-person hearing. And it means that counsellors are being transparent about following the hearing, or at least giving a good impression of following the hearing. It will be essential, I think, to monitor the hearing for technical problems, ideally with a democratic services officer or somebody in charge of the technology to spot if people drop connection or are having technical difficulties, and to notify the chair, crucially, so that the hearing can be paused and time given for whoever's lost connection to rejoin, if necessary, for assistance to be given to the member so that they can reconnect, perhaps not over the internet. They could even dial in by the phone. I think virtually all video conferencing platforms now allow you to dial in on the phone if you're really having difficulty using an online connection. If a member misses part of the hearing, there will be a judgment call primarily for the member in question, but I think also for the chair. If the member's only missed a small part of the hearing, it probably would be quite easy to simply recap what the member has missed, to summarise what the parties have said or what the evidence might have been. If the members missed a more substantial chunk or perhaps a particularly important passage of the hearing, then a judgment needs to be made about whether it would be fair for that member to be part of the decision-making panel, or whether actually they should recuse themselves. I think primarily that's a matter for the member in question to confirm, both in their own mind and publicly to everyone at the hearing, whether they can fairly reach a decision on the application or whatever it may be. But it may also be that the chair, where there's potentially a dispute there, the chair will have to make a ruling on that, bearing in mind the rules about quorum. So I think ideally we should be pausing the proceedings and allowing the member to rejoin where possible. Now, similar rules apply to attendance by the parties. It's essential that all parties have a fair opportunity to make their case and to hear what other parties are saying. And by parties here, obviously, I also include residents and other third parties who've made relevant representations and therefore under the hearings regulations are treated as full parties to the hearing, at least in theory, of equal standing to the premises, to the responsible authorities. Now, we know in terms of access to the public, hearings have to take place in public unless the committee resolves to exclude the press and public from the hearing. But members of the public only have limited rights of access, and that is essentially to follow the proceedings, to hear them, and ideally to see them as well. But they otherwise have no right to participate unless they've made relevant representations. So on that basis, usually a live stream of the hearing, it will be sufficient to satisfy the requirement that the hearing takes place in public. Provision also needs to be made to allow for the committee to deliberate and come to a decision in private. That's certainly, when I sit as a legal advisor, that's by far the better way, in my view, of coming to a decision, although I'm aware of at least one authority that deliberates in public. This is usually done by either asking all the parties to simply leave the main hearing room and leaving members and their legal advisor in the hearing, and somehow getting a message back to the parties that they can rejoin. I think better, based on experience, and I'm sure you found this as well, to set up a separate breakout room for the decision-making panel to leave the main hearing room, come back together in a secure breakout room, have that discussion, and then return to the main hearing room, leaving the parties waiting, probably with their cameras and microphones turned off, for the deliberation to conclude and the decision to be announced in the presence of all the parties. It may also be, but certainly some authorities simply prefer to end the hearing at that point and to communicate a decision within the 5 working days allowed under the hearings regulations. Practice may differ. Do whatever works best for you, but make sure this is covered in some way in the protocol. The final point to make is that this is about disorderly conduct and the power to manage the hearings and hearing in that sense. Now, thankfully, in licensing hearings, in person and remotely, disorderly conduct is rare, but where it does happen, the chair needs to be able to respond as they would do in a in-person hearing. And in many ways, it's easier to deal with disorderly conduct in a remote hearings context because there are meeting controls available that are very difficult to override if you set up the meeting properly, which is now almost invariably done because we're very familiar with how these platforms work. And it's possible that the chair might have control over the button, but probably more commonly it'd be a democratic services officer who will be able to promptly remove participants from the hearing where the chair directs that to be done in the light of or in response to disorderly conduct. Now that's it for the kind of substance of what I wanted to say. What the final point, I guess, is a reflection, which is that since the decision came out, I've had lots of messages from people who've been very interested to read it. And a lot of them have said, well, finally, the court has recognized the common sense of allowing licensing authorities to hold remote hearings. And I agree with that. One of the interesting points that came out of the case is that although the appellant said, well, it's essential that a remote hearing is conducted fairly. Well, the counsel obviously couldn't disagree with that point, but the appellant, on the facts of this case, never pointed to any aspect of unfairness or anything that they said was unfair about the way that the committee went about revoking its license. They disagreed with the merits, as they're entitled to do, but they had no substantive complaint that they'd been denied a fair hearing. And that, in my view, is telling. In principle, provided that the committee acts fairly, everyone has a fair opportunity to make their case. There's no reason why licensing authorities should be prevented from taking advantage of the tremendous convenience that platforms like Teams and Zoom allow, and that have become the norm in most workplaces, including local authorities. So we can only hope that eventually the new government comes around to saying the same thing about ordinary meetings of local authorities as well. But I wouldn't hold your breath on that for now. So thank you very much for listening. We've got plenty of time for questions. It's only just gone 10:30. So if you've got any questions, please feel free to put them in the Q&A, or you'd be welcome to get in touch with me separately, and I'll be speaking at the National Training Conference for the IOL in November, not about remote hearings, but there is a panel. I think Gary Grant is doing that. I'll be speaking about the role of the police in the licensing system with my excellent colleague Jackson Zarika, who I'm sure at least some of you will know and hopefully will get to know in the years to follow. But Robert has asked a question: if the local authorities' procedure rules provide that all decisions shall be determined by a majority of members present in the room, do you think this might preclude remote hearings and require amendments of the local authorities' procedure rules, at least insofar as those rules apply to licensing subcommittee hearings? It's an interesting question. I'd say to avoid the risk of challenge on this point, it might be sensible to amend those procedural rules. But I don't think in that situation I'd say it's essential, because what the hearing tells us very clearly is that a place for in the context of the hearings regulations could be an online place, and a hearing could be in an online or a remote hearing. A hearing could be a remote hearing, and so I think that would strongly influence the interpretation we give to the individual procedural rules for whichever counsel Robert is involved with. So the room there, I think, could be quite comfortably interpreted as the online meeting room or words to that effect. So I don't think an amendment's essential, but certainly if you're tidying up procedure rules, or if you're thinking of adopting as a constitutional document a formal set of procedures for remote hearings, it might be sensible just to make that kind of tidying up amendment so that there aren't any complaints. But I think it's probably a fairly minor point, because the court has now very clearly told us that licensing hearings, remote hearings, are permissible. So I hope, Robert, I've covered that question. So Stephanie's asked, would a meeting of full council be needed to adopt a remote hearing protocol, or is a licensing committee constituted? As a licensing committee is constituted under the Act, it's only necessary for the committee itself or even the subcommittee to adopt the protocol? I think the answer is the latter. I don't see it as essential for a meeting of full council to adopt, I guess, as a formal constitutional document, because the licensing committee has express statutory authority to regulate its own procedure, and I think that does include adopting a protocol that applies. So I don't think it's necessary to do that, but obviously if you're going down the constitutional route, I think it would be, because only full council would have authority to make substantive amendments to the constitution. So Stephanie, I hope that answers your question. Sheila says the council I work for holds far more taxi licensing hearings, which are also held in person. As these fall under the 1972 Act, it would seem that the new decision cannot allow them to be held remotely. Do I agree? The answer is yes. So this decision only applies to hearings before the licensing committee. Now, lots of authorities I work with have separate 2003 Act licensing committees and general licensing committees. Depends on the kind of balance of work that they do. And the general licensing committee will deal with all other licensing functions: taxis, gambling, street trading, scrap metal, those kinds of things. So yes, this ruling and what we've been talking about today only applies to 2003 Act hearings. It doesn't apply, even whether the Licensing Act 2003 committee is involved. It doesn't apply to things like the adoption of statements of licensing policy, because those are not items of business that are dealt with under the 2003 Act. So for policy issues, that would also need to be an in-person meeting, and it's governed under the 1972 Act as well. So Sheila, I hope that answers your question as well. Robert, I think it's coming back to me. Is it not arguable that the flexibility at a hearing permitted by Section 9.3 in the hearings regulations only applies once the hearing has been convened, i.e. flexibility does not include venue? Was that put forward as an argument in the High Court? I think that was the appellant's argument, and that argument was not accepted by the court. What the court was looking for was some indication in the hearings regulations that said remote hearings are not allowed, and the court couldn't find an indication like that. So the implication was that if a licensing authority chose to adopt a remote hearing, they were entitled to do so under the hearings regulations, because there was nothing to prevent them from doing that. So I think it's an admirably clear judgment. I don't think there's any room for doubt now as to the principle. There may be, as Robert's indicated, some questions around the margins about standing orders and other constitutional rules, but I don't imagine that they are going to be a major impediment to moving or continuing with or moving back to some form of remote hearings procedure. So I think, unless anybody wants to pop another question in the Q&A function, we'll draw a line under things there. Thank you very much again for listening and attending, and I look forward to seeing as many of you either at IOL events or otherwise. Do feel free to get in touch with questions or observations, anecdotes about how things are going. It'll be very interesting to hear how this plays out in practice. And so I wish everyone a very good day. Thank you for joining us.